Okay, so we are live. Hello and welcome everyone to Family Law Fridays, presented by Florida Women's Law Group. I'm Jadlyn Fleischer, a legal intern here at Florida Women's Law Group. Family Law Fridays is designed to be a resource for all women with any type of family law issue. Today we'll be discussing how to handle alimony and child support issues during COVID-19. Before we get started, I would like to give you some information about our host. Our host is Heather Quick, founder and CEO of Florida Women's Law Group, which is a family law firm that advocates for women in North Florida. The firm educates and empowers women on their rights and the law so that they can find the strength to endure the process and end up better financially and emotionally. Heather Quick has been a licensed Florida attorney for the past 20 years, with the majority of her practice over the years being in family law. Please join me in welcoming Heather Quick to Family Law Fridays.
Good morning, everyone, and happy Friday. I don't know about you, but some days I'm like, is it the weekend or not? And it's not that I don't have stuff to do. It's just the part of the times, and we're not leaving the house every day. The kids aren't leaving the house every day. So for me, it gets a little bit odd, and I imagine that it's similar for the rest of you too. I'd love to know different ways everyone is dealing with that and trying to have fun, bring some normalcy back to our day-to-day. I do think we're about to see hopefully a shift, certainly within the country, and allowing everyone to get out more and get back to normal. So, fortunately at Florida Women's Law Group, we've been able to stay on track and continue working, which is wonderful for the business, for all of our clients, that they're not left in the dark or without a response or answers to their issues. As well as the employees, because we have a great team, and they're working away at home. So that is one part that has remained the same, and we continue to have a lot of calls in, a lot of questions to our office, probably because we are open and trying to put out there as much information as we can related to family law, specifically for women. And that's why your questions, your concerns are so important, because as I've said before, if you have them, so does someone else. If we can answer it and at least begin you in the right path, that is our goal and our desire for everyone. So today, I wanted to touch on a topic that I talk about a lot, and anyone who is divorced, most people who are divorced, have had some either dealings with it, have some issues, questions in regards to alimony and child support. Now, in the current situation, we have a lot of issues coming up and calls, and then the question becomes, what can I do right now? So that's what I hope to answer for you in that manner. And I will switch back and forth on if you're receiving alimony, if you're paying. I have different advice for different folks, but at the end of the day, it all ends up being the same, which is understanding and believing that things are going to get back to a version of the way they were before. From a perspective of the court system, it's certainly not going to completely get back, because we've all changed, been impacted by what's happened. But to take action to do certain things right now, as if we're in a vacuum, or as if it won't come back later, I would advise against that. It will. And for anyone who has experienced being in court and having a hearing, trial, anything in front of a judge, your bad acts in the past do come back to haunt you. It's just behavior. It's the way you interact with your ex-spouse and how that impacts the children, if there's children, how you interact with your ex-spouse, how you address your financial obligations. It all comes back. And it's something I use all the time. We don't have to have this particular pandemic, stay-at-home order, all of that. There's a lot of bad behavior, and it's finding it and bringing it to the attention of the court. Now, whether it's just to make a claim, have a stronger argument for attorney's fees to be reimbursed, or just address the credibility of your ex-spouse, that's where those things are helpful. So let's talk first about alimony, because that generally within the evaluation, we do address alimony first, because that's the income paid to the spouse, the wife in this example, by the husband. So right now we're in a situation where some people, depending on your industry, are laid off, on furlough, may have been fired. I don't know. There's a lot that is currently going on in the environment we're in. So the question is, if you're the spouse who is to be receiving alimony and your ex informs you that they have had a change in employment, and that's one way it'll go. I'll tell you, all of you can imagine the more of the reality is the check just doesn't come in the mail, the deposit is not made. You then have to reach out to your ex and say, what's going on? Always uncomfortable. Nobody really wants to do it. They either take your call or they don't. Sometimes there's, not a nice response. And then you call us, another attorney, say, what do I do? And then that requires you to take action to enforce what the court has ordered you to have. So let's say that scenario for one, it is April 15th. If your check was due by the 15th, you didn't get it. That's a little late in the month, but everybody's agreement is different. Or maybe you get 2 payments per month. You got the first one and you haven't gotten the second one yet, and you're getting concerned. So as far as, it depends upon what court you're in, what circuit, and what judges are addressing it. But it is going to be important to take action to enforce, your order. It is on you to do that. Now, granted, if your ex has had a change in employment, had a change in status, it is totally his responsibility to file for a reduction. Typically, we see the reduction, the contempt first, the reduction. At the end of the day, he's not paying, it is contempt. And he should continue to pay until a court order reduces that income, that alimony. So in that situation, I'm just checking. So if that's the case and you are not receiving a check, you have and have no communication with your ex, I would suggest reaching out to your to the you have been using. If you don't have one, call us, have a consultation. Let's evaluate the situation. And so that's the one. If there's just no communication and no money and you're wanting to know what to do, you are going to have to go enforce that. And right now, taxes are delayed in being paid. Most individuals will have filed, most likely if they're getting a refund. It's usually who owe taxes, delay, don't really pay early. So now there's a delay there. That could work to your advantage depending on the level of income your ex has. And if they've delayed that payment, they shouldn't. So that's one, if there's no communication. Now, let's talk about if there is communication between you and your former spouse on the alimony. They're having a hard time and they are, reached out to you, explained the situation, and want to reduce the amount they're going to pay or not pay anything. Now, those are two very different scenarios depending on where you are. Most women who receive alimony rely on that alimony for income. It's not a savings part, and they don't have always employment to supplement that or other income. That may be your case. That's important to know for sure and to consider. But even if their income's reduced and you still need that alimony, I would suggest negotiating a lower rate only on a temporary basis. And what I would recommend is entering into a consent agreement, a contract between the two of you that you agree to accept, say, $200,000 less. Let's just say half. You're getting, say, $5,000. Say, I will take $3,000 a month for a period of 6 months. You need to limit it, because if it's just open-ended, makes it harder later on. Having dealt with many agreements to go back and enforce with the court, you think you've written the best agreement, and I'm not faulting any of the drafters of them, because everybody has intent. Usually there's attorneys drafting it. If you did it in your spouse without attorneys, then I would blame the drafters, because you guys tend to leave a lot out. And it doesn't matter until you need to enforce, until later. And then it's a mess. Just a side note, because I've dealt with it. But it doesn't mean we can't go address it. So don't do that on your own. If there's a situation where you and your former spouse are on good terms, communicating about the amount of income he's receiving, his financial situation, your financial situation, then I suggest that if you do it, and it means, hey, you're getting a little bit less now, but it's better than him completely cutting you off, and then you trying to figure out how am I going to get relief in the court system, which takes time. And so therefore, what I would recommend is coming to terms that are on a temporary basis and reducing that to writing. That is the best way, because this is not going to be a permanent situation. And some individuals, he may not be doing great now and then may get an even better job after the fact. And so therefore, you want to make sure, if you're entering into agreement, that it's not going to hurt you later. So that's the key. Get legal advice. Even if you two have agreed, memorialize that in writing and get legal advice on what needs to be included in that agreement on the reduction of alimony. That's really important. And it's an issue that we've dealt with a lot right now. And because it's going to take longer in the court system than it would have, so even, 5 months ago, and it still takes a while, but this gives you some relief, him some relief, without worrying, well, who's going to file? What am I going to do? And only relying on the courts to resolve it. We are employing a lot of different creative ways to help individuals move through their divorces, move through their post-divorce issues, so that they can get closure and move forward and not have to wait necessarily on the judge. So that would be the recommendation on that. Now, if then we are dealing, if you're paying alimony, if you are the breadwinner, you have an order of alimony and you're impacted, I would, again, recommend strongly that you get something in writing, because it does come back. It all comes back. I get it that your income is decreased, but there's ways to minimize specifically exposure to attorney's fees. And because that can be a really big hit. So if you can take the better action, take good action now. Understand if the communication is not productive or pleasant. I understand many, exes prefer to have no contact whatsoever. They'll exchange the funds, don't want to talk to them. I get that. So let us do it for you. Let us do the communication. Let's at least do everything we can to mitigate your future exposure. And you should be concerned about it because you're going to regret it later and think, oh, I wish I had done that. Hindsight always being 2020. I'm telling you now, I've been there plenty of times for the clients, and I know what it looks like on the other side. So that's the alimony. Lot of probably other issues that can come back if it's a temporary order, so you're not divorced, but you do have an order. We can really handle things in the same way. But since you're already in litigation, you're in the middle of it, we can even do more, and we can verify that information, and we can do a deposition, even if we can't get a hearing quickly, and address a lot of things and really look at the overall pictures. It's going to be a long-term setback on the income. Do we need to do more discovery? Dig in a little bit more, or is this going to be something that's going to rebound? So let's try to look at that and know this is just a short-term issue, and maybe we can agree, hey, you're going to get that money back later. So those are all very important things to consider. So now let's talk about child support. We've talked a lot in the webinars we've done. If you were unable to attend any of those, please look on Facebook. I know they're there, and we can, I'm just looking at my computer. We can work to make that, I think I've lost, we can send you the video, because time sharing impacts child support. Will it impact the child support you're receiving right now? Maybe, maybe not. There's so many issues. They actually, if you look at the tax and income stimulus webinar I did with Josh Schultz earlier this week, that should still be on Facebook, or reach out to our office. We will be posting it on the site as on YouTube. But look at that, because that addresses issues that have more to do with the finances. But as we know, and if you don't know, child support is very much directly related to the amount of time the children are at either parent on an overnight basis. That's how we calculate it. And it also has to do with the income of each party. So really a couple issues that I have seen come up lately. One is similar to the alimony, has changed due to the current COVID situation. And, there may be a situation where they are still getting paid, but they're not being forthright about that. Hard to say. A lot of businesses are seeking economic assistance, but very few have received it as of yet. Same with those stimulus checks. So again, if that is the issue, again, there's the same scenario. Either there's a good communication about the fact that income has gone down, change in their status, what can we work together financially? That's the best scenario. Always is. Doesn't always happen, but I know it does. And consider, understand from my perspective as the attorney, divorce and post-divorce attorney, the ones that work out most of the time don't call us. But I do know so many do. So many times you think you're going to be able to work it out and you can't. So it's, the view that I'm bringing you is the one from certainly the lawyer's perspective, but also what I see happening down the road in court based on our experience representing individuals. Just so that's important to consider. I think, and we advise our clients all the time, because the way you present yourself and how you've handled yourself when you weren't in front of the court is just as important, because if it was bad behavior, somebody's bringing it up. I promise you that. How much does it matter? It just depends on what was happening. So with the financials, either communication or not, we can, a temporary order or an agreement is important to the extent that we're talking about the child support is impacted and is lowered, but you can't waive it. So it's not something that you can arbitrarily waive. It's your child's right to be supported. Now you can tweak the amount for a temporary period of time. And as we've discussed so many times over the past couple of weeks in these webinars, the children are home, they're not in school, and they are, require much more care even during the day. So child support does fluctuate or does adjust according to overnights, but even if there's not, depending on the daytime schedules and with schooling, and it may impact what's going on. And one of you may be able to work and the other not. And now is the time for, obviously for everybody to do what they can to keep things going. So if you're able to have a conversation, that's great. We can help you and advise you as to this should be memorialized in writing in some fashion. Does it need to be in a formal order that we're sending to the judge? Maybe not, maybe just a written agreement, that because it's on a temporary basis. And same for if you're in the middle of the divorce and you have a temporary order, or you are waiting on a temporary order and now you don't know when your hearing is going to be. That is a situation that we've had in a few cases, depending again on what circuit you're in. There are some things we can do to assist you. Now, does that take the cooperation of everybody and the other attorney? Yes, it does to some extent. There are some things that we can move forward on, and we can't certainly make anybody agree to anything. And it may not be in your best interest based on the temporary situation we're in now, knowing that it is going to change. A financial situation should be much improved in the future. So we don't want to settle on numbers now that really aren't going to be the reality later. You're setting yourself to go back to court. And that is never a great idea. You need to be a little bit more long-sighted. You need to see a little bit longer, not just do the short term, get it over, because it's painful. It'll be really painful in another year. Think, oh, now I have to go back to court because I settled on this temporary financials. It's not enough to support me and my children. So on the child support. So we have the issue of time sharing, how it impacts the number, alimony impacts the number, and of course, income. So those are things that now, if they're paying $1,000 in child support, they're changing the job, changing the situation, asking to reduce it. We can help you come up with a number. Most individuals that I find, they're like, well, let me just cut it in half. The problem is you're still going to have that issue and well, it's not adequate. Does it meet the formula? Probably not, because they're telling you this is what they think they can pay. What they think they can pay is usually less than what they can pay. And right now, if they have the child more, then they're feeding them more, and clothing and taking care of them. So that may be a way to say, all right, well, you take the kids for this temporary period of time more often so that we can balance the food bill and just the time, in our own sanity. I know for myself personally and lots of other women, we've lost a lot of our personal time, whether you work or from home or outside the home, but our children are home. Our children certainly in primary school, and then a lot, and all the college students are home. So, and we have nowhere to go. So there's not even the time in the car, really. That's your own time. So it's important that if you and your ex are getting along and communicating, and if you're not, maybe let us, talk to an attorney that maybe can facilitate that, because you both need a break and you both need to do what you can to get through this and help your children. So if there is a way that, all right, well, your financial situation has changed. The time that the children are home has clearly changed. So let's come up with a temporary agreement. You're not agreeing, keep this in mind, you're not agreeing to change whatever has been in place to now a 50-50 arrangement with all, with a completely different schedule, because life is going to go back. And that's why it's important to talk to an attorney. I am not suggesting that you come to an agreement that completely alters the underlying parenting plan and financial obligations. And unless that's what you want, and then, let's talk it through and think that through. That may be what both of you want. I'm okay with that. I just want you to be clear that these times right now where we are at these stay-at-home orders, the children are being schooled virtually, don't know if they're going to go back, don't know what's going to happen with different employment as maybe we begin to open things back up. So you just want to protect yourself. I want you to do the best you can, make the best decisions, but at least consult an attorney definitely always before signing something, and just to get advice. Is this something that should be in writing to help, or is this something that could come back later and now I am stuck with this new arrangement that was not my intention going into it? So those are the main issues that we're seeing now. And, I just wanted to discuss it because the courts are open. I had 2 hearings this week, just like this, on video chat. The judge can see everyone. The client, you can see the judge, all the attorneys. So on one hand, that's very efficient because everyone can stay where they are and log in. And, all you need is good internet. But not every courthouse, every circuit is doing that. So for the ones that are, we're doing our best to keep moving through. The ones that are not addressing these types of hearings and issues, there are other things we can do. And our goal at Florida Women's Law Group is to help you achieve your goal and objectives throughout this process, but also to help you get on with your life. The longer you're in the middle of litigation and involved in the court system, the longer you spend kind of doing that, moving forward and moving on. And that is personally important to me, important to do everything we can for our clients, because I'd rather see you around more often, not just in the courtroom and through litigation. I'd like to see you move on with your life, begin that second chapter without, just the stress and unknown sometimes of litigation. So if you are experiencing any issue as it relates to alimony paying or receiving, child support paying or receiving, and things aren't going the way they're supposed to, you're concerned that maybe something will happen, that also is an issue. So at least we can always strategize, give our clients a roadmap to, when you see A, B, and C, now's the time, or these would be indicators that this would be a good move for you. And it's just based on all of our attorneys in the office having done this for so long. And despite although we haven't had a pandemic before, we've had certainly other issues that impact things that are going on in the court system. But What we can tell you with a high degree of certainty is what we would believe will happen. We just may not know when, in front of what judge, and what are the best steps you can take to get where you want to be. And that is all we want for you. We want to answer questions. The goal with these Family Law Fridays are, when I can give you some information that I am hopeful helps you understand, discern your current situation and make better decisions, then that is a win for us and hopefully a win for you. Sometimes it may just bring up questions that you didn't even know you had, but at least it allows you to begin thinking about things so that maybe you're not blindsided. I believe that's very important. And of course, we bring guests on as often as we can to talk about really relevant issues right now. And all of these are issues that are affecting every single one of us, but depending on your particular family situation, it's different. So when you post-divorce or in the middle of a divorce or contemplating divorce, it's important to understand right now what's going on. How does that impact your particular family situation? So I thank you for tuning in. And if there was something you wanted specifically answered that we didn't get to, please reach out, comment. Someone will answer your question on Facebook, or give our office a call at 241-0012, and that's area code 904. Also on FloridaWomen'sLawGroup.com. We have a lot of resources for you and are happy to assist in the best way we can. I thank you again for attending, and we look forward to seeing you and helping you in the future.
Yeah, of course. So thank you everyone who was able to listen in today for Family Law Fridays. As always, if there is a topic you would like addressed or a question you'd like answered, please call, email, or send us a Facebook message, and it could be addressed in an upcoming video. We hope you found the information helpful today. As Heather mentioned, if you think of any additional questions over the next few days, please call our office or send us a message. We're available by phone, like she said, 904-241-0012. Thank you, everyone, and see you next time.